Welcome to the deep dive. Today, we're diving into a legal battle that's making waves in the tech world. Lava, the Indian mobile phone maker, is going head-to-head with Ericsson, the Swedish telecom giant. You've given us a ton of legal documents, judgments, expert testimonies, you name it, and we're going to break it all down. We're going to understand what's at the heart of this case.
What's so interesting here is that this case really shows how complex the relationship is between technology, intellectual property, and global business. This case goes way beyond just these two companies. It gives us a peek into standard essential patents, SAPs.
Exactly, and SEPs, those are a big deal. We'll find out why they're so essential and how they can spark these international legal battles.
This case actually gets into some pretty fundamental questions about intellectual property, especially in the digital age and especially when it comes to software patents.
Right. So Ericsson says Lava's using its patented tech in their phones without paying up. But Lava's fighting back. They're saying some of Ericsson's patents shouldn't even be valid.
Well, Ericsson has a really long history in the telecom industry. They've played a key role in developing those mobile communication standards that we all rely on, from 2G all the way to 5G. So they have a massive portfolio of patents, some of them even for older technologies.
Wait, patents for 2G? I thought that was ancient history. My first phone could barely send a text message.
That's a pretty common misunderstanding. Even those older technologies often form the foundation for the newer ones. Think of it like the foundation of a house. You might not see it, but the whole structure depends on it.
Okay, so even though we've moved way beyond 2G, those early innovations are still part of how our phones work today.
Exactly. Now let's look at some of these patents.
Sounds good. So the first one is IN 23034. This one has to do with how speech is encoded for mobile phones. Lava says it's just an algorithm and not something physical, so it shouldn't be patentable. What did the judge say about that?
Well, this raises a big question. Where is the line between a mathematical concept and an actual invention that you can patent, especially now with everything digital? The judge really had to examine the patent closely and listen to the experts from both sides. They acknowledged that IN 2334 does use algorithms, but it's more than just an abstract idea.
So it's not just about the math, it's how it's used in a real device.
Right. The judge said this patent describes a specific way it's implemented, the hardware involved, and its effect on mobile devices. All of that makes it patentable.
So the details really matter. What about the next patent?
Okay, let's look at NN 2336. This patent talks about a piece of hardware and apparatus that processes speech signals. It creates parameters that let you reconstruct the original speech.
So this sounds a little more concrete than just an algorithm.
Yeah.
What's Lava's problem with this one?
Well, Lava argues that it basically boils down to a math formula that runs on software. They say it doesn't describe a real physical device or apparatus.
So it comes back to that question. When does software cross the line and become a patentable invention?
Yeah, and that's a debate that keeps coming up in the legal world. Now, Ericsson says this patent clearly lays out the specific hardware and its effects. They even use diagrams in the document itself, and they point out that it's not just theoretical. This patent is used in real communication systems, and it affects how our phones work.
Sounds like they're trying to show that this patent is more than just an idea.
Yeah.
Did they convince the judge?
They did. The judge agreed with Ericsson. They said that even though it uses algorithms, it goes beyond just equations. The important part is that it's focused on producing those specific parameters that let you rebuild the speech signal. That shows a clear technical goal.
Not just the math itself, but the purpose and how it's used in the real world. Okay, what about the next one? What's the deal with this patent?
Okay, this one's called IN 234157, and it's all about codebook selection.
Code book selection. Sounds kind of like a spy movie. What is that?
Think of a codebook as a dictionary for your phone. When you speak, your phone turns your voice into digital code. The codebook is like a list of all the possible sounds with their own unique code. So codebook selection is like picking the right words to represent your voice clearly and efficiently.
So this patent's about making sure our calls sound good.
Exactly. This patent describes how to pick the right codebook for different parts of a speech signal. It makes things more efficient and improves the quality. Now, Lava says this is just an algorithm running on a computer and that they're just following the ETSI standards. Those are the rules for mobile communications.
So they're saying they're just following the rules. They shouldn't be penalized.
That's their argument. But Ericsson fired back. They said this patent offers a special and innovative solution that's more than just following the rules. They said it directly affects how phones process and transmit speech.
So again, it's about the specifics of the solution, not just the general idea. What did the judge say about this codebook patent?
The judge got really technical here. They compared the details of the patent to those ETSI standards that Lava mentioned. They were looking for key differences. And in the end, they sided with Ericsson.
So another win for Ericsson.
Yep. The judge said, INN 234157 is a valid and unique invention. It offers a special approach to codebook selection that goes beyond the general rules of the standards.
Okay, let's move on. What's next? Tell us about this one.
This one's EN 23686, and it's all about a method for transmitting and receiving information. It specifically focuses on something called codec modes.
Codec modes. Lots of technical jargon here. Can you explain that so even I can understand?
Think of codec modes like gears in a car. You shift gears depending on the driving conditions.
Right.
Codec modes are kind of similar. They're used based on things like network quality and the type of data being sent. This patent describes how to manage those modes effectively, which makes calls clearer and uses bandwidth better.
Okay, I get it. So what's Lava's problem this time? Are they saying this method's been around forever?
You got it. Lava claims it's not a new invention, and they even dug up some old documents to try to prove it.
Oh, like what?
Well, one was a research paper from 1936 called the Newfoundland Azores High-Speed Duplex Cable.
1936?
Yeah,
That's before smartphones even existed. What does that have to do with Ericsson's patent?
I know it sounds weird, right? But Lava said this paper talks about two-way communication, which they claim is a basic part of the method in this patent. They're saying the idea was already out there.
So they went way back in time to try to prove their point. Did it work?
Not really. The judge looked at whether that old research paper really connected to the specific method in Ericsson's patent. And after thinking about it, they dismissed Lava's argument.
So that old paper wasn't the magic bullet they were hoping for.
Nope. The judge ruled that EN 23686 is a new invention. They said it tackles a specific technical problem in how we manage codec modes for good communication. And that specific solution, they said, wasn't found in any previous work, not even that old cable paper.
Okay, so Ericsson's 4 for 4. What's the next patent on the list?
All right, let's talk about AN 213723. This one's all about making comfort noise in a speech decoder.
Comfort noise. What's that? Like the opposite of white noise?
It's a bit more subtle than that. Think about when you're on a call and there are moments of silence when the other person isn't talking. Total silence can sound unnatural, even a little creepy. Comfort noise is that quiet background sound that fills in those gaps to make the call sound more natural.
Wow, I never even noticed that. So what's Lava's issue with this one?
They're saying that using comfort noise was already a common thing in telecommunications way before this patent. They pointed to things like a 1996 GSM recommendation that talks about comfort noise functions.
Sounds like their strategy is to prove that Ericsson's not really describing anything truly new.
You got it. But Ericsson says, no, no, no. Our patent describes a special and improved method for making comfort noise. They say it analyzes the background noise to make it sound even more natural.
So Ericsson's going for a more high-tech approach. What did the judge think?
The judge agreed with Ericsson again. They said, IN 213723 is a new invention. They said, yes, there were earlier ways to do comfort noise, but Ericsson's method is a big improvement because it sounds more natural and less distracting.
5 for 5. Ericsson's really showing their expertise.
Yeah.
What's next on the list?
Okay, now we've got IN 240471. This one focuses on mobile radio and how it manages handovers in a mobile communication system.
Back to the world of phones. Can you remind me what a handover is? Why is it important?
Sure. Imagine you're driving along, talking on your phone. As you move around, your phone has to switch from one cell tower to the next to keep the call going. That's a handover. This patent is all about how a phone measures and reports signal information, which helps the network manage those handovers smoothly.
So it keeps our calls from dropping when we're on the move. Pretty important.
You got it. And guess what? Lava says this patent isn't new either.
I think I see a pattern here.
They brought up a research paper from 1998 about CDMA systems. That stands for Code Division Multiple Access. It's a different type of mobile tech.
Another blast from the past. How does that paper relate to Ericsson's patent?
Well, that paper talked about handovers in those CDMA systems. It mentioned things like soft handoff, where a phone connects to multiple base stations at the same time. Lava argued that those ideas are essential to how the handover method in Ericsson's patent works.
So they're saying Ericsson just took old ideas from a different kind of mobile technology. Did the judge buy it?
Nope. The judge said that even though the research paper talked about handover ideas in general, it didn't actually describe the specific method that Ericsson patented. They pointed out that Ericsson's patent is all about an event-based approach where the phone only sends reports to the network when certain things happen.
Event-based. So it only reports when it needs to. Sounds
Yeah.
efficient.
Yes, exactly. It's all about cutting down on unnecessary communication between your phone and the network. Saves battery life and helps the network run better.
So another point for Ericsson, they're on a roll.
Yes. The judge ruled that NN240471 is a new invention and that this event-based handover method is a real step forward compared to what was already out there.
All right, next patent on our list. What do we have here?
This one's NN229632. It's all about multiple data transmission services. It describes how a mobile phone and a base station can handle those services over a communication link.
Multiple data transmission services. You mean like when we're doing a million things on our phones at once?
It's-
Streaming music while uploading videos and checking email.
Exactly. Handling all that at the same time can be a real challenge, technically. This patent is all about managing all those different data streams efficiently so everything runs smoothly and nothing gets bogged down.
Okay, I'm seeing a theme here. So is Lava saying that managing multiple data streams was already a solved problem?
That's right. They're arguing that this patent is obvious, meaning it wouldn't have been hard to come up with. They presented some old documents to try to prove it.
What kind of documents did they use?
One was a technical document from 1998 called MobiWare. It talked about how to adapt the way data is transmitted for multimedia.
So it's about adapting how data is sent. How does that relate to Ericsson's patent?
Lava's arguing that the ideas in this document, especially those about managing different types of data with different quality needs, basically anticipate what's described in Ericsson's patent.
So they're saying Ericsson's just rehashing old ideas about data transmission again. What did the judge think about that?
The judge really scrutinized both MobiWare and Ericsson's patent, looking closely at the technical details. They said that MobiWare does talk about general concepts of adapting how data is transported, but it doesn't describe the specific method that Ericsson patented.
So the judge is looking for specifics, not just general ideas.
Exactly, and Ericsson did have those specifics. The judge said their patent focuses on a unique method of putting different data services onto a single channel. It prioritizes data blocks for transmission and schedules transmission rates to make things work best. None of that was in MobiWare.
Okay, so Ericsson had enough evidence to show that their invention was different from that older document. Did they win this one too?
Yes, they did. The judge ruled that NN229632 is a new invention and not an obvious one considering the evidence Lava presented.
6 out of 6 for Ericsson. They're really winning this battle. What's next?
Let's talk about patent NN241747. This one's all about handling errors in communication systems, specifically using something called automatic repeat request, or ARQ.
I think I can guess what's coming. Is Lava going to argue that this is another old idea?
Yep, you guessed it. They said using ARQ for error correction was already well known before this patent. They even brought out a bunch of research papers and technical documents from the 1990s.
So they're basically saying Ericsson is trying to patent something that everyone already knew back then.
Right, but Ericsson, as always, disagrees. They say their patent describes a unique and improved way to implement ARQ that makes data transmission more reliable and efficient in mobile devices.
We're back to that debate about general ideas versus specific implementations. What did the judge have to say this time?
The judge very carefully reviewed all of those old documents that Lava presented. They compared them to what was in Ericsson's patent. They were trying to find specific details or techniques that were unique to Ericsson's invention.
So it wasn't enough for Ericsson to just say they were using ARQ. They had
No.
to show that their way of doing it was special.
Right. And they did. The judge pointed out a few key things about Ericsson's method that made it different. For example, the patent talks about breaking up data blocks into smaller pieces and retransmitting them in different ways.
So it's like tailoring the error correction to each specific situation.
Exactly. This helps ensure that data gets transmitted reliably even when the connection isn't great.
Sounds like another win for Ericsson.
It is. The judge sided with Ericsson and said NN241747 is a new and not obvious invention. They recognized that even though ARQ was known, Ericsson's specific way of doing it was a significant improvement.
7 patents, and Ericsson's still undefeated. What's next?
Now we come to the last patent in this case, Invala 23686. It also deals with managing codec modes in communication systems.
Wait a minute, haven't we already talked about a codec mode patent? This sounds familiar.
You're right, we have. We already covered patent IN 23686. It was that one where Lava brought up the research paper about undersea cables.
Oh, right. So we're back to that patent about managing the different gears for optimal communication.
Yes, we are. And the judge has already decided this patent is a new invention.
I remember. So why are we talking about it again? What's different this time?
This time, it's not about whether the patent is valid. It's about whether it's a standard essential patent or SEP.
Okay. I think I'm starting to see the difference.
Yeah.
So a patent can be a cool invention, but that doesn't automatically make it essential to a particular standard, right?
Exactly. A standard essential patent, or SEP, is a patent that covers technology that is absolutely necessary to implement a particular industry standard. Standards are like rule books that ensure different devices can work together seamlessly. We're talking about the standard for mobile communications here.
So Ericsson has to prove that their patent is crucial to how our phones work for it to be considered NCEPI.
You got it. And this is where the real battle begins. Lava is arguing that even if this patent is valid, it's not actually essential to the standard.
So they're saying, sure, it's a neat invention, but we can build our phones without using it.
That's a good way to put it. They're arguing that there are other ways to achieve the same functionality without using what's in Ericsson's patent.
Okay, this is getting interesting. How does Ericsson respond to that?
Well, they had to prove this patent is essential. So they presented evidence. They used what are called claim charts. These charts show how the things in their patent match up with the specific technical requirements of the mobile communication standard.
So it's like a side-by-side comparison to show that what's in the patent is actually needed for the standard to work.
Exactly. They're trying to show that this technology is woven into the very fabric of the standard.
Clever. So what did Lava say about those claim charts?
Well, they argued that Ericsson didn't prove that their patent covers all the possible ways to implement the standard.
So they're not completely denying that Ericsson's technology might be one way to do it. They're just saying it's not the only way.
Right. They're trying to raise doubts about whether Ericsson's patent is absolutely necessary.
Clever strategy. But did it work? What did the judge think?
Well, the judge had to look at all the evidence and decide whether Ericsson had really proven that INN 23686 is a standard essential patent.
The moment of truth. What was the verdict?
The judge ruled in favor of Ericsson.
Wow. So after all that back and forth, Ericsson still wins.
Yeah, the judge decided that Ericsson had enough evidence to prove that INN 23686 is really essential to the mobile communication standard.
So they were convinced by those claim charts.
Exactly. The judge said the charts clearly show the connection between the patent and the technical requirements of the standard. It wasn't enough for Lava to just say there might be other ways to do it. They needed to show some real proof, and they didn't.
Okay, so 8 for 8 for Ericsson. They won on all their patents, and they proved that this one's an SP. So does that mean Lava has to pay up?
Well, hold on a second. Remember, Ericsson has agreed to license its SPs on FRAND terms. Fair, reasonable, and non-discriminatory.
Right. FRAND. That's starting to sound familiar, so this isn't over yet.
Oh, no, not at all. The next part of the story is all about FRAND. Lava and Ericsson are now fighting over what's a fair royalty rate.
So it's like they agreed to play the game, but now they're arguing over the rules.
Perfect analogy. Lava's saying that Ericsson is being ridiculous with the royalties they're asking for. They say Ericsson's trying to take advantage.
It's David versus Goliath. So how do you figure out what a FRAND rate should be? There has to be some logic to it, right?
You're absolutely right. It's not just a random number. Determining a FRAND rate is really complicated. It involves looking at a lot of factors.
Like what?
Well, you have to consider how valuable the technology is. How much did it cost to develop? Is it really unique? Then you look at other licensing agreements. What are other companies paying for similar technology? You also have to factor in how much money Lava is making from the devices that use this tech. And then there's the impact on the whole industry. If the royalty rate's too high, could it hurt competition or slow down innovation?
Wow, that's a lot to think about. Sounds like the judge had a tough job. So what did Lava and Ericsson present to support their arguments about the royalty rate?
Both sides brought in the experts, economists, analysts, tons of data to try and win over the judge. Ericsson pointed to its other licensing agreements. They argued that the rates they were asking from Lava were in line with what everyone else was paying. It's kind of like the everyone else is doing it defense.
So they're saying, we're not treating Lava any differently.
Exactly. They're trying to show they have a history of being fair and reasonable with their licensing.
Makes sense.
Yeah.
What about Lava? What was their counter-argument?
Lava focused on a specific licensing program called CiproLab and used that as their benchmark. CiproLab was a patent pool that handled licenses for 3G technology. Lava argued that Ericsson's rates were much higher than what CiproLab was offering. They were basically saying, look, there's already a system in place for licensing similar tech at a lower rate, so why should we pay Ericsson more?
So they used a real-world example to show that Ericsson was being unreasonable.
Exactly. Smart strategy, but it didn't work out as they planned.
How come? It seems like a good comparison.
Well, the judge took a hard look at Ciprolab and decided it wasn't a good comparison for this
Oh,
case.
that must have hurt. Why wasn't it relevant?
The judge said that Ciprolab was all about WCDMA technology. That's just one piece of the bigger 3G standard. Ericsson's patents cover a lot more 3G technologies, so using a narrow patent pool like Ciprolab to set the rate for Ericsson's entire portfolio didn't make sense.
Like comparing apples and oranges.
Exactly. So Lava had to find a different way to convince the judge that Ericsson's rates were unfair.
What do they try next? Any other tricks up their sleeve?
They did. They brought up something called royalty stacking.
Royalty stacking. What is that?
It's a big issue in the tech world. Imagine building a smartphone. It uses a ton of different technologies all working together, right? The screen, the processor, the wireless communication, all that. And each of those technologies might be covered by patents from different companies.
Okay, I'm with you so far.
Now imagine each of those companies wants a high royalty for their technology. The cost of making that smartphone goes way up, so high that it's not worth making anymore, or the price for consumers goes through the roof.
Okay, I see where this is going. So Lava's saying if they have to pay high rates to Ericsson, on top of all the other royalties they have to pay, it'll make their phones too expensive.
You got it. They argued that would hurt competition in the smartphone market, make prices go up for everyone, and ultimately slow down innovation.
It sounds like they're painting a pretty grim picture. Did the judge buy it?
The judge acknowledged that royalty stacking is a real problem. Courts all over the world are trying to figure it out. But in this case, they weren't convinced by Lava's argument.
Why not? It seems like a valid concern.
Lava didn't actually show the judge any proof of what they were paying in royalties to other companies. They didn't show the judge they were facing this huge royalty burden they were talking about.
So they can't just say, oh, we might have to pay a lot in royalties. They have to show the actual numbers.
Exactly. Hard evidence, not just hypotheticals. So with the royalty stacking argument out the window, Lava had to try something else.
Okay, I'm on the edge of my seat. What was their next move?
They went on the attack. They accused Ericsson of holdup.
Hold up. Like a bank robbery. What does that even mean here?
It's not quite as dramatic as a bank robbery, but it can feel that way for the companies involved. In patent law, holdup is when a company with an SIP uses that to demand unfair royalties from companies that need to use the technology.
So it's like Ericsson is saying, you need our tech, so you're stuck with us and have to pay whatever we want.
That's the gist of Lava's argument. They're trying to make Ericsson look like the bad guy, using their patents as weapons to squash the competition and drive prices up.
Pretty serious accusation. What proof did they offer?
Well, they pointed out that Ericsson had sued them multiple times. Lava said this was a tactic to pressure them into agreeing to a high royalty rate, like using the legal system as a weapon.
This is getting intense. What did the judge think about this holdup argument?
Not really. The judge was super thorough, as you'd expect. They looked at the whole history of negotiations between Lava and Ericsson, all the back and forth, to see if Ericsson was really acting in bad faith.
Looking for evidence of bad behavior.
Exactly. And this is where things take a turn. The judge found that Lava wasn't so innocent either. They said Lava wasn't being a willing licensee, basically hinting that they weren't negotiating fairly either.
Hold on. The judge is saying Lava was playing games too. What did they do?
The judge found evidence that Lava had stalled the negotiations. They didn't give counteroffers. They even filed a lawsuit right before a meeting with Ericsson. Not exactly the actions of someone who wants to make a deal.
So both sides were trying to outsmart each other. Did the judge call them out on it?
They did. The judge said that FRAND negotiations need both sides to try to reach a fair deal. They said the legal system should be used to resolve things fairly, not as a weapon or a way to manipulate the other side.
I like this, Judge. They're not letting anyone get away with anything. So after all that about FRAND, comparable licenses, royalty stacking, and holdup, what did the judge decide about the royalty rate? What number did they come up with?
That's the million-dollar question, isn't it? The judge really did their research. They looked at all the financial data, all the licensing agreements from different companies, and all the relevant factors to figure out what a FRAND rate would be in this case.
Tell me, what was the verdict?
The judge ruled that a FRAND royalty rate for Lava would be 1.05% of the net selling price of their devices.
1.05%. That's way lower than I expected after all that legal fighting.
It does sound small. But we're talking about a percentage of a lot of phones. This means Lava has to pay Ericsson a royalty for every device they sell that uses this technology.
Ah, so even though the percentage is small, it adds up to a big chunk of money, especially since Lava sells millions of phones.
You got it. And this decision is a big deal for other licensing agreements, too. It could even affect negotiations across the whole mobile phone industry.
Wow. This is huge. I feel like we've just watched a legal drama unfold with all the twists and turns.
It really gives you a glimpse into this world of intellectual property technology standards and how we try to balance promoting new ideas with keeping competition fair.
Totally. We started by trying to figure out complex algorithms, and now we're experts in international licensing agreements. What a journey. Oh, one more question before we wrap things up. Lava also has to pay damages for using Ericsson's patents without a license right. How did the judge figure out how much they owe?
That's another important part of this case. The judge took into account the whole time Lava was using the technology without a license, and that goes all the way back to 2011. They also looked at how many devices Lava sold during that time.
So they didn't just pick a random number? There's a formula for this.
Absolutely. They used that 1.05% FRAND rate they just decided on and applied it to all the devices Lava sold since 2011.
Wow, those damages are going to be massive. This whole case is like a warning sign for any company thinking about ignoring patents or trying to cheat the system.
It definitely shows how important it is to respect patents, negotiate in good faith, and understand how licensing works, especially in this fast-changing tech world.
Well said. Thank you for walking us through this battle between Lava and Ericsson. It's been really eye-opening. I think we've all learned a lot about patent disputes, RAND licensing, and the world of technology and innovation.
You're welcome. It's been great diving deep with you.
And to all of you listening out there, thank you for joining us. The world of technology keeps changing, and so do the laws around it. So keep learning, keep asking questions, and until next time, happy diving.